SJC-13286, Jason Dacey v. Sandy Burgess.
Okay, Attorney Collier.
Chief Justices. Mr. Dacey, a disabled father of three, walked into housing court seeking a restraining order for repair of conditions in his property. Instead of a judicial hearing, he was steered into mediation, and he left that courthouse that day evicted. The housing court's
He didn't leave it evicted. He left it with how many? What did he leave with? He left with a free month and how many years of, or how many months? What are the facts?
The facts are that he could not. The execution couldn't issue until that summer, not years, Your Honor. That summer.
Didn't issue
and then
that
of
summer,
course the COVID.
Didn't issue that summer. It was to stay for another year.
Yes, but that was not as a result of the court's order or of the eviction. That was as a result of the COVID stay, Your Honor. What he walked out with that day was an order that permitted his eviction, despite the language in the agreement that said he would only that he would be leaving voluntarily. But regardless, Your Honors, that decision and the housing court's enforcement of it violated the straight-up statute that says...
Can I ask a question? I just want to try to pin this down. So you're a landlord and you have a tenant. The tenant's not paying. You like the tenant. You work out a deal. You're just between yourselves. You work out a deal. I'm going to let you stay three more months, and then you're going to leave. And the tenant says, great. And they actually write that down. And then the tenant changes his mind 5 months later. Is that also unenforceable?
Your Honor, it may be enforceable in a summary judgment case.
But
it's not enforceable in a sanitary code enforcement.
So even if he leaves the property voluntarily, enters into agreement, and walks away, as this happens a lot out there, that thing is totally unenforceable. You just have to use a summary. You got to start over in a summary process. Is that your view? I'm just trying to understand what is not allowed anymore, or what is.
What the legislature said is not allowed, Your Honor, is that
but
no
person. Can you answer my question though?
Yes.
If you voluntarily work out a deal to leave an apartment, and you both agree to that deal and walk away from it, and then you change your mind 3 or 4 months later, was that an illegal deal in your view? Does it have no legal consequence?
Your Honor, I thought I answered. No person shall attempt to recover possession other than through a summary process action. It does have legal consequence. You can seek to enforce that agreement through a summary process action, or in the language of a statute, another proceeding authorized by law for the recovery of possession.
So all these voluntary arrangements out there to end leases, to walk away, work out your deals, they're all totally extra legal in your view. I'm just trying to get a sense of the scope of this, of what you're asking. Is that right?
No, Your Honor, that's not what I'm arguing. I'm saying that those are legal agreements, Your Honor, just as any time you sign a lease and it expires, it's a legal agreement that the tenant will move. But you don't get to just move them out at that point. To enforce that legal agreement,
what if they
you
left?
must bring a summary process action.
If they left on their own and then changed their mind, was that still improper?
Once they've surrendered possession, of course not, Your Honor. Once you surrender possession, you surrender possession. You don't have a right to go back and say, you have to evict me, because you couldn't be evicted at that point. You no longer have possession, Your Honor, in the language of this court in Hatcher.
Okay, so that we're not, at least we're not undermining all of that. Once you've left, we don't have to worry about this. I'm just trying to
Exactly, Your Honor. Voluntary agreements that the parties perform are perfectly legal in any context, including in possession of premises.
So as soon as that person walks out, they've lost the ability to use the summary process.
Because they don't have possession, Your Honor. That's exactly right. For summary process rights to accrue, there has to be an action to recover possession.
Okay.
Once a landlord has recovered possession, the landlord doesn't have to do anything.
Okay.
They now hold the property pursuant to real property law, and the agreement has been performed. It's done. There is no further question. But, Your Honor, I think what's important here is what the legislature said, because the legislature has decided this case. The legislature said...
You say that, but it's premised on your belief that the only way to recover possession is through a summary process action.
No,
That's,
Your Honor.
well, if it's not, why isn't it okay that they go to mediation on your client's petition? They go to a housing court specialist. They go and he got some benefit for it, because wasn't there some number of months where he was allowed to remain in possession without having to pay any rent?
Your Honor, there was a single month's rent waived, but Your Honor, summary process law entitled this disabled person to a year's stay. Eviction law entitled him to defenses, to access to tenancy preservation project for a mentally ill person.
Not free though, right?
Sorry?
Not stay without having to pay.
No, but this tenant never didn't pay his rent, Your Honor.
But didn't he say he didn't want to pay the increase? That was why this whole
but-
thing started?
But not paying an increase is different from not paying the rent, Your Honor.
I understand.
If a tenant doesn't consent to an increase, the rent doesn't go up. So for that period of a year, he would have gone on lawfully paying the contract rent, and that would have been legal. But more importantly, Your Honor, he would have had access to all the services that are available in the housing court to preserve tenancies and to preserve the tenancies of disabled persons.
And are you saying you
particu-
can't waive those, that the tenant can't waive those in any?
The tenant cannot waive those, and the legislature has said that. The legislature, in saying no person shall attempt to recover possession in any manner other than through a summary process action or another action authorized by law for the recovery of possession.
That's the last part, which isn't so clear, right? Or any other action authorized by law. That's why we're here.
So, Your Honor, the argument that was made below is that if there's a case, you can get possession.
Well, remember, you chose not you, but your client went into the other forum, right? It wasn't like he surreptitiously brought you into a different court. Your client brought the other action, right? And then the court ordered mediation, but again, you chose the forum, and you agreed to the deal. Now, the disability thing is complicated because I don't know, nothing was said about disability at the initial proceeding, right? The judge wasn't alerted that this person had a disability. And by the way, doesn't the disability also have to relate to your ability? I mean, if I'm in a wheelchair, that doesn't matter as long as I can get into the courthouse. If you're arguing in a wheelchair, you're as equally capable of arguing, right? It has to be a disability that affects your ability to argue, right?
Your Honor, this court has said with regard to the reasonable accommodation issue, two things. First, that once the court is informed of the disability,
right?
And here the court was informed of the disability well before
the court was
entered.
The court was informed of the court wasn't informed of the disability when your client negotiated the deal, right?
The court was not, Your Honor, but reasonable accommodation law literally says, and this court has affirmed it, that all the way through execution, the reasonable accommodation obligation survives.
So he
that
alerts
once you
the
move
court.
them out, it does not.
When he alerts, your client alerts. How does he alerts through an affidavit that says what?
That says he receives Social Security disability. He's disabled by mental illness, including bipolar mental illness and depression.
That's before the judge in enforcing the judgment, right?
Before the judgment is entered. That's right, Your Honor. Before judgment for possession is issued.
I'm just trying to make sure you're not subtly answering that question. when they go into court to enforce the mediation,
Yes.
does your client alert to the disability issue up front, or is this something that comes up later? When does it actually happen?
The first time the disability is asserted is in response to the landlord's motion to enforce the agreement. So before there's any judicial ruling at all. And Your Honor, the court's decision here violates everything this court has said about accommodation.
Was there a hearing? I can't remember. Was there an actual hearing in this case?
There was a argument on the motions, but there was no evidentiary hearing or other inquiry ever conducted. And there is remarkably, in the face of this court's rulings in McDonough and Ajardi, no mention of disability in this judge's decision. And what this court said in Ajardi and in McDonough was that once a disability issue is presented to the court must first make inquiry into the disability, and second, and that's this court's language, the court must inquire into the disability, and second, the court must make findings sufficient to permit appellate review. It's not just that the housing court here didn't make findings sufficient for appellate review, Your Honors. There's a 4-page decision here which never mentions the word disability, which never mentions the term reasonable accommodation. There is not a single finding or reference anywhere in the court's decision to the fact that Mr. Dacey was mentally ill and walked into a mediation where the landlord was represented with no idea of what was happening to him, and walked out believing, according to his affidavit, that when he said he would move voluntarily, he could not be evicted under that agreement. Now, whatever else there is to say about the decision below here, you cannot say that never mentioning his disability, never mentioning his mental health problems, never mentioning his understanding of voluntarily moving out constitutes factual findings sufficient to permit appellate review. Similarly, endorsing the landlord's use of a mediation in a case brought to enforce the sanitary code to recover possession is exactly what the legislature did not agree to when it said you can't do it in any manner other than an action through Chapter 239 or other action authorized by law. And Your Honors, respectfully,
Take a minute.
the legislature has
Can we
said,
just
oh,
take-
sorry,
take-
excuse
take
me,
a-
Judge.
Excuse me. Can we just take a minute to separate the Ajardi situation from the subject matter jurisdiction issue just for a second, and just specifically say when it was in this process, specifically, that your client alerted to the judge to the Ajardi situation, to the disability? When did that happen?
October of 2020, before judgment entered in the case, Your Honor.
And when was the first agreement?
The agreement was March, I believe. No, February, Your Honor. February of, I'm wrong again, March of 2020.
And then it happens in October. Is that when this?
But I
and just want-
misspoke. October 2021, because there was a year when the housing court couldn't.
I'm not faulting.
Couldn't issue
I'm just trying to.
evictions. Yes.
I'm just trying to get at relative to the voluntary, the order, let's say, that reflected the agreement, and taking into account when there was a 1-year stay. In that process, when is it specifically that the judge is informed of the disability issue?
The judge was informed of the disability in response to a motion brought immediately after the COVID bar expired. The COVID bar expired, I believe, mid-September of 2021. The landlord promptly moved for judgment and execution, and the tenant, in an affidavit and in a memorandum in response, said, "I'm mentally ill, I'm disabled. I thought this was voluntary, and it is not. Please don't evict me. It will render I and my children homeless." So that was in October of 2021. And that disability was raised before the court at least 3 times, in October, in January, and later in January on the Rule 59 motion. Ajardi was cited for the court's obligation to inquire into, to make reasonable accommodation and make findings repeatedly in this process. The court was cited over and over again to Chapter 184, Section 18, saying he can't recover in any manner. And, Your Honor, the legislature has explained that it believes in can't recover in any manner by amending Chapter 13919, which is the quick eviction statute, over and over again to expand the circumstances under which a landlord can recover possession other than through summary process. Used to say only for alcohol, then it was amended to provide it could be used outside of summary process for alcohol and drugs, then for firearms, then for violence, then for public housing tenants. So the legislature has understood its own command in 184.18 as a limitation on the right to recover. And the court and the legislature has again and again said, we need to add this one to the ways you can recover without going through summary process because this is serious enough so that we're not going to make you resort to summary process. None of those amendments were necessary. If a landlord could just go in on a sanitary code action or in a small claims case and get a judgment, sue the tenant for $50, go to small claims mediation and get a judgment for possession. Go in on this is no different than a person filing for a domestic violence restraining order and walking out evicted.
You brought it there. They didn't bring it there. Your client brought it there. They didn't manipulate the process. You took them into that process. And then the question is, can that mediator work out, an agreement? Now, you've raised a separate issue whether that mediator can work out an agreement with someone who's disabled. That's the third issue. But the court clearly had jurisdiction over this. You brought it there.
It had jurisdiction over the parties, Your Honor. It didn't have jurisdiction over the claim for possession. This is the same as a domestic violence plaintiff going into court for a domestic restraining order and walking out of the domestic violence mediation with them moving out of the property and waiving their right to live in the family home in response to a case that they brought to protect themselves from domestic violence. The case that Mr. Dacey brought to this court was a case asking for a repair order. It wasn't a case asking for the mediator to adjudicate him homeless. It wasn't a case asking for the mediator to ignore his disabilities and move him out.
Counsel, can I just go back for a second, though? But you're not suggesting that if a plaintiff in a civil restraining order were granted an order of protection that ordered the defendant to vacate the premises, that somehow that would be unlawful because it's not in the context of a summary process action, right?
No, Your Honor, although it's my understanding that the domestic violence restraining order process requires vacating, but does not adjudicate the claim to possession of the family home.
Well, I mean,
that's got to be done in the divorce or in a permanent dissolution relationship.
well, that's talking about maybe title, but not possession. I mean, certainly. But anyway, let me just go back here for a second. There were a variety of procedural things that happened between the time of the agreement in March of 2020 and the time that it's first raised to the court in October of 2021. The parties had been back and forth a couple of times to the court, and not at any point was the issue of any disability raised. Why not?
Because, Your Honor, the tenant was in those hearings doing what the tenant understood the tenant was doing when it brought this case, which was the tenant was trying to get repairs made, the bed bugs.
Sure, but there isn't any allegation here that the tenant couldn't read and understand the terms of the agreement. The terms of the agreement said explicitly that the tenant was to vacate by August of 2021. There wasn't anything that was conditional about that, that was somehow mysterious about that. It said you have to leave by August of 2020.
Yes, voluntarily, Your Honor. There was nothing that made this unrepresented mentally ill tenant aware that he could then be evicted if he did not move voluntarily. We can all say, maybe he should have guessed that he was at risk of that and done something to vacate this agreement. Maybe a person who was not mentally ill, depressed, and still trying to deal with bed bugs and living through the midst of a
What we're trying to
COVID
do
bar.
is figure out where the Ajardi issue needs to be raised. Again, I'm putting aside the subject matter jurisdiction issue, because if you're right on that, then we don't need to address it. But so let's say you're in the summary process session, the tenant's pro se, there's mediation, there's an agreement for judgment, and it's a non-payment of rent. And in consideration of the agreement for judgment, the landlord says that we're not going to execute on this for 2 months. 2 months passes, or the day before 2 months passes, and there's a injunction from the tenant that there's an Ajardi issue, and they're raising it now. Is that okay?
Yes, Your Honor. And this court held in Bridgewater specifically that the tenant showing up at trial and never having sought accommodation before trial and judgment was timely asserting his right. And in fact, the tenant in the Bridgewater's case, which is this court's primary precedent on reasonable accommodation, never even said, I want an accommodation. He showed up and testified that he was off his medication because his medication had been changed. And that was his entire showing. And this court reversed the housing court and found that he was entitled to a reasonable accommodation, and that the court's failure to do so violated his rights under both the federal and state anti-handicap discrimination law. In addition, Your Honor, decisional law is unanimous that as long as the tenant is still in possession, that is, until the execution is actually carried out, is levied upon, the court must consider a request for reasonable accommodation. This court has not weighed in on that, but the circuit courts around the country have. The housing court's practice is through execution, the court will require consideration of a reasonable accommodation. Here, reasonable accommodation is never mentioned. There's not a word. Here, disability is never mentioned. There's not a word. If Ajardi and McDonough mean anything, Your Honor, then they mean that where that issue is squarely presented before the court has entered a judgment, the court cannot enter a judgment without the Ajardi-McDonough inquiry, and the court can't enter a judgment without making sufficient findings to permit reasonable appellate review.
We're going to have to ask you to stop now. Thank you. Okay, Attorney Bull.
Good morning. May it please the court, I'm Attorney Patrick Bull. I represent the defendant in this case. And to follow up on some of the questions you had, the judge did in fact give him a reasonable accommodation. When we went for the execution, the judge specifically said, I'm going to give you up to a year, but I don't give it all at once. I give it every 3 months. And
But that's different from the disability accommodation is a different issue.
Right.
Your opposing counsel says essentially this. I mean, say we agree with you on the substance, that you can, they brought you to that process, they have subject matter jurisdiction, their mediation can work out their differences including him leaving the property. But he's now arguing that Ajardi has a clear disability notice provision. And if you're on notice, and he says, I notified you that I'm disabled when you sought to enforce the mediation, the agreed upon mediation judgment. Doesn't the judge have to address the fact of whether he was competent to negotiate for himself in this regard? Doesn't he have to make certain findings under Ajardi to do that?
I think the first step is that the plaintiff has to articulate what his disability is. It's like saying, I'm going to give you a wheelchair ramp when you're dyslexic. It's not going to help you. And to your point, nothing impacted his ability to argue.
Well, but he's again, and I'm not a mental health expert, and I got to reread that affidavit, but he says he's bipolar and mentally ill, right?
And depression. He says, I'm disabled, comma, and I have bipolar and depression. He told my client, according to her affidavit, that he had a bad back. That was his disability that he gets paid for.
But does the judge have to can we sort this out here? He raises issues about his mental capacities. He may not have done it well, but does the judge have to, under Ajardi, say, okay, he's claiming, again, various things. I find when he went through that mediation, he knew what he was doing and could make that. Does he have to make those findings?
I will say this. The judge in this case dealt with Mr. Dacey. There was a number of hearings where he made findings about Mr. Dacey because he says in his decision that I find he wasn't coerced, wasn't confused about what happened.
He says he wasn't confused?
I think, I don't have the judgment in front of me, but I think he said he definitely wasn't unduly influenced or coerced, I think. Because they were claiming that somehow I had tricked him into agreeing to leave. And just quickly, he was given 5.5 months where he couldn't be evicted, by the way. That's what the landlord gave. That wasn't a concession by him, it was a concession by the landlord.
And no one's suggesting the landlord is behaving inappropriately here, but there are complications, particularly the disability issue without findings. I think help us here, if you can.
If I may, the Sparrow case speaks to this. And the Sparrow case specifically mentions that you have to give more than just an affidavit. You have to give medical evidence to show that. And the thing is, he was, to the point before, this was like a year and a half later is when he first brought it up. So he gets the benefit of the bargain. He gets the money. He gets the 7 months where he can't be evicted. And then when, as I said in my brief, you get to the finish line, he goes, oh, by the way, I got a mental illness stop. And it's just like you said, you come up with you come up with an agreement, and right before execution is about to issue, I'm sorry.
I'm totally sympathetic to what you're arguing, but does the judge have to confront that and address it? That's what I'm concerned about. Because the judge could simply say, guess what? I found him, he knew what he was doing, he took advantage of this, and he's very clever, and I don't buy it. Then we're not here, right?
Right. Well, I would say that I think he has to address it, or it has to be brought up prior to entering into the agreement, because then, you hit the nail on the head with your hypothetical. That could happen in every single contract that we have in the state of Massachusetts. You get to
A different answer to the question. Let's say that there's a tenant who has serious mental health issues and really isn't going to understand what's going to be happening in the mediation. And in the mediation, there's an agreement for judgment. The agreement for judgment, even though there's on a non-payment, a right to 14 days, there's an agreement, something significant given up, 6 months at the same rent, well, even throw in 1 month free. So now it's time for the execution, and the tenant comes in and raises the Ajardi issue, and raises it appropriately. It's not just an affidavit. It comes in, it's got a psychotherapist willing to testify, showing the meds. It's legitimate. That tenant really didn't understand what was going on in that mediation. Can you raise that issue after the judgment on the day the execution is going to issue?
I think that would be up to the judge's discretion. I think it's a much stronger case than we have here. So I would say, I could see the judge using his discretion and taking that into consideration is, okay, I do have the evidence now, as opposed to what you mentioned, a one-line affidavit, which appears to be carefully drafted, if you will, because his disability that has been documented and he gets paid for is for a bad back and a bad neck.
And the
is what he
issue
told.
for us is whether or not, it's not the timing,
Okay.
it's whether or not there was a sufficient notice on the disability issue, and whether or not, once there was notice, whether or not it was grounded enough that the judge was required to address it.
And Counsel, could I follow up on Justice Lowy's point? Because I see this, as I dug into it, just maybe slightly differently than opposing counsel. My understanding of Vajjarti was, it needs to be the court, before we get to reasonable accommodation, the court needs to make a finding of disability. And if we look at the judge's decision in this case, and if not explicit, implicitly saying, I don't credit that you have a disability that is because that's the way I was looking at the judge's decision here, that it was raised at the time of looking for the execution, and the decision seems to discredit that.
And I think you're correct, Your Honor. That and the judge in this case, this is why it's important. The judge in this case had met with Mr. Dacey, had spoken with Mr. Dacey on numerous occasions, and you can see through the court record here. He did not find anything credible. And actually said in one of his hearings that we talked about the subsequent bedbugs, he actually said to Mr. Dacey, I find what you're saying to me doesn't match the facts. So I don't say didn't, I think he discredited Mr. Dacey's, all of a sudden, again, we're at the finish line, I have a mental agility, a complaint here. And I think the judge did discredit it. And again, there wasn't an evidentiary hearing, but there was numerous times throughout this process where he did deal with Mr. Dacey and spoke to him personally in the hearing. I'd been at the hearing. The other thing I think that was brought up, I don't want to change the subject, but
By the way, did
Go ahead.
Mr. Dacey argue for himself in front of Judge Puerto?
I don't believe so.
So he was represented by counsel at that point?
Yes, he was.
So when you say the judge had a lot of exposure to Mr. Dacey,
He had brought other complaints.
other complaints?
He had brought other complaints to the housing court that were addressed in one of the judge's decisions.
Okay, but that's different.
He had brought another motion, correct. So he had dealt with Mr. Dacey, and quite frankly, I don't believe he found him credible. May I touch on one other subject? The 18418 that my brother had mentioned here about, you can evict someone through, such other proceedings as authorized by law. Just as a little background, I did some digging in this, and the history of this statute is a little different. When this was first introduced, it was Senate Bill, I think, 589, and it was introduced by Senator Bulger, actually. And the title of the act was, An Act Prohibiting Eviction Other Than Due Process of Law. That was the title. And the language was different. It says, no person shall attempt to recover possession of land or tenements in any manner other than through an action brought pursuant to Chapter 239, or such proceedings as are authorized by statute. So that was in the initial bill that they filed. And that language came out. So contrary to what my brother's saying about, hey, you got to have another statute that authorizes this, they keep amending the nuisance statute, that's not the case. 18418 wasn't set to handcuff the judiciary. It was to make sure there's no self-help evictions. They wanted someone a judicial proceeding to overlook it, to make sure things are going as they should. So, and again, they took the language out. Now it's such other proceedings as authorized by law. And I think that's a very important distinction. If they wanted it to just be by statute, they could have left the language in there. So 239 isn't the only way to regain possession of a property.
Other questions?
Nope.
Thank you very much. We ask you affirm the lower court decision.